Good day, everybody, and welcome to the first edition of John's Rants for 2023. I'm John Giardinelli. I'm the association's attorney, and we're going to cover some multiple listing service rule violations today and some other things related to both the Code of Ethics and the multiple listing service. So real quickly, there's been a couple of changes to the Code of Ethics for 2023. Nothing particularly significant, but I want to make sure that you're aware of them. First is in Article 3, and that's the article that talks about the duty to cooperate for the benefit of the clients. In Article 1, there is a standard of practice that says that it is the listing agent's obligation to check with the owner and or the seller to confirm how access is to be authorized for entry into the listed property. There's been a change in Article 3, Standard of Practice 3-9. In that particular section, they've made it consistent. Under the rule that existed in 2022, it said that a buyer's broker was obligated to comply with the instructions of the seller and or the listing agent. They've deleted the word listing agent and included the word seller. So now it reads the same exact way as standard of practice in Article 1. So again, a minor change, but the bottom line is this, is that it is the owner/seller's right to determine for themselves how access to property is to be granted, and it is an ethical responsibility to follow those instructions. There's also been some changes, not only in Article 10, but in every article that deals with discrimination. Under the old rule, they used the word handicap to describe the protected class. They've deleted the word handicap everywhere that it appears in both Article 10 and everywhere else in the Code of Ethics, and replaced it with the word handicap, which is a little broader term. In Article 15, there has always been a statement that you shall not make inappropriate, false, or exaggerated statements, basically defamatory statements about other real estate professionals. But up until this year, they've never defined what that means. In Article 11, there is a definition of real estate professional, and that has now been adopted into Article 15 as well. So it reads basically that if a person engages in residential real estate brokerage, real estate property management, commercial and or industrial real estate brokerage, land brokerage, real estate appraisal, real estate consulting, real estate syndication, auction and or international real estate, that is the definition of a real estate professional. And if you make false or misleading statements about them, either in verbal tone or in writing, including social media, you can be held to a standard under the Code of Ethics, and that could cost you several $1,000s in fines. As everyone knows, under CAR, there have been some new forms that we're going to cover in brown bags and some other classes. They deal with buyer-broker relationships. It's a very fluid area, so be aware and keep track of when your association is going to be offering classes on the subject. There have been some changes to the procuring cause guidelines. They want people, they being CAR, want people to use the procuring cause, the buyer broker representation forms. They believe it's important. It's probably emerging as a standard of practice. And so if you get into a dispute with another real estate professional over who is entitled to the buyer side of the compensation, hearing panels will be looking at whether or not you have a buyer-broker representation agreement. And if you do, there's going to be a greater chance of your prevailing. So a word to the wise. Now we're going to have a meeting in February with your professional standards people, and they're going to decide exactly what weight they're going to give that, and we'll report to you at some time down the future. So let's talk about the multiple listing service. I had a conversation with the compliance attorney. His name is Jeff Smetana. He's a fabulous lawyer and very fair man. And so you should remember that name, Jeff Smetana. Jeff is a compliance attorney for CRMLS and is the person, his staff are the people to contact if you get in trouble. Couple of things that one of the things that Jeff and I talked about was he's seeing more brokers get in trouble because their agents don't fix MLS violations. So here's the deal. Under NAR rules, if a person receives more than 3 citations, it must go to the grievance committee as an ethics violation. Now, they will then either set it for trial, they will determine if codes of ethics violations need to be added. They're going to fix all that up. But the bottom line is here's what's going on that seems to be a problem. I'm the broker. I have a number of agents. Agent number 1 doesn't fix the violation, neither does agent number 2, neither does agent number 3. So even though I'm not particularly directly guilty of an MLS citation and none of my agents have more than 3, the fact that all these listings belong to me and I'm obligated to supervise and I'm obligated to make sure these things get fixed. Once the 4th agent gets a violation, I'm going to go before the association and its ethics committee, a grievance committee, and I'm going to be held to a standard that could cost me a great deal of money and some problems. We had one situation in one of the associations that I represent where a broker wasn't paying attention to the notices that were coming in from the MLS, and she ended up having 19 citations that had to be fixed, and it became a real problem for her. So don't get yourself in that situation. Keep an eye on emails that come in or letters that come in from the MLS, and make sure that you get on your agents to get those things taken care of one way or the other, or you're going to end up having a problem with the grievance committee. There is also some information that was provided to us regarding warnings. Again, you have, generally speaking, and there's some specifics, so pay attention to whatever you get from the MLS. Generally speaking, you have 2 days, that's regular calendar days, so it doesn't matter what day of the week it comes in on. You have 2 days from the time that you get a warning to fix a violation. And if you do that, under most circumstances, no harm, no foul, no fine, no nothing. So be aware of that. You're going to typically get a warning. Now, what does receipt of the warning look like? Well, if you have the violation mailed to you, it is presumed that you received it 3 days after it has been mailed. Remember, these are calendar days, not business days. So if you get something mailed to you on Friday, then they count Saturday, Sunday, Monday. On Tuesday, it is deemed to be delivered to you. If they email it to you, then it's 1 day after delivery. I am sorry, I said days. It is business days. So receipt. So that means if I get, let's say I'm doing this rant on January 13th, a Friday. Monday is considered a holiday, so they don't count Saturday, Sunday, or Monday. The first day would be Tuesday. I apologize for that oversight. Fines are going to be due if you get a fine. 20 days. Now, these are calendar days, 20 days after you get notice of a fine. Because these rules are passed by the board of directors at CRMLS, staff does not have the authority to either reduce or modify a fine. So you're wasting your time trying to get them to do that. Generally speaking, if you don't think that the fine or the citation is fair or correct, you still must fix that. And you have 20 days to then appeal that citation. You need to fix it first, and then the association has a procedure in effect for you to appeal, and you can appeal in one of two ways. I strongly recommend that you appeal on what is called a paper review. In that context, you will fill out the paperwork, you will explain why you don't believe the citation is fair and or reasonable and or compliant with the rules. That will be looked at by 3 members of the Pacific West Association's Professional Standards Committee, and they'll make a decision on the paperwork. If they find that you're guilty, there's no ups, no extras, no reporting, no nothing. It's just as if it went straight to you're taking care of it. If they find you not guilty, they'll let you know. And of course, that means that the fine will be modified or reduced or dismissed. You are entitled, however, to a full-blown appeal. If you decide to do that, it will go to grievance. There will be a hearing scheduled. It will be no different than any other hearing, except that the Professional Standards Committee is not bound by the decision of CRMLS as to how they're going to find you. So you could end up with a much larger fine, an ethics violation, plus all the time you're going to spend potentially having to hire a lawyer or getting somebody else to represent you. It is very, very cumbersome, but it is a full and complete review. So what are the most likely MLS violations? Well, CRMLS let us know that there are 7 that sort of seem to come up all the time. And so I'm going to just go over those with you. There are requirements under MLS Rule 11.5.1 that require an exterior photo. The manner of the photo, what's in the photo, all of those issues must be uploaded within 2 calendar days after uploading the listing. If you fail to do that, you're going to get hit with a warning and potentially a fine if you fail to comply. Number 2 are branded photos. These are where you're putting a photo in the MLS, but you're branding it in some fashion. So either your sign, we actually saw one realtor who put her sign on a pillow on a bedroom a photograph. And remember, the purpose of the multiple listing service is to provide information to the public and other members of the multiple listing service about property that is available for purchase and or for rent. So it is not a place for you to advertise your office and or yourself for the purpose of trying to double in. The third category that comes up a lot is copywriting issues. You don't own the photo or whatever information you are linking, and you fail to comply with whatever requirements they are under the MLS's photograph rules. So you need to understand that there are rules. You can't use somebody else's photo without their express written permission. It is a violation of the law, and it can lead to some serious financial implications for you. So you need to be very, very careful about how you deal with photographs. If you have an agreement with the photographer, if you've complied with CRMLS's photograph rules, then you should be fine. If on the other hand, you fail to do that, you could be in violation. There is not going to be any warning. This is going to be a fairly substantial fine, because if CRMLS posts a photo that is a violation of copyright, they themselves could be sued. So they take that very, very seriously. The next category that seems to come up a lot is mandatory delivery of a listing agreement, which is a violation of MLS Rule 7-8. This is a situation where you fail to register the listing within 2 days after you obtain it. Remember that you are to register that listing within 2 days, or file something indicating that your seller has advised you that you shall not put the listing in the MLS. And so again, remember that. If you commence marketing and fail to submit the listing, that is a violation of Rule 7-9. It occurs when you start publicly marketing property. And remember, if you're using coming soon or some other form of off-market notification, that you must notify the MLS within 1 business day. So again, you don't count Saturday, you don't count Sunday, you don't count holidays. Misuse of public remarks, which is a violation of Rule 12-5. If you insert in public remarks things like gate codes, showing instructions, compensation information, lockbox, occupancy status, email address, website address, phone numbers, agent or brokerage information, open house information, or language that violates fair housing, and that goes into the public facing remarks, then you can be subject to a fine if the MLS believes that those are inappropriate, and the MLS has the right to remove the offensive language from public remarks if they discover it. And then the last category is inaccurate information. Any information that is inaccurate, failing to notify of a status change, failing to disclose any inaccurate information. It's one of the cornerstones of the MLS is that we want you to have good, solid data. And so the failure to include accurate data is going to be a problem for you on a go-forward basis. All right, so a couple of quick things to remind you about. Number one, don't ignore citations or warnings or things of that nature. Deal with them. Deal with these issues of changing status quickly. Deal with these things because, again, this is a database with information in it. It's nothing more than that. And at the end of the day, if the data is not accurate, it wastes people's time and energy, could end up causing some problems. And so the MLS is dedicated to making sure that their data is as clean as possible. And all of you have an obligation to participate in that. Remember that coming soon is an off-market strategy, and it's good for 21 days. After that, it automatically becomes active. And while you're in coming soon, there are limitations on marketing because all you're really doing is saying, hey, this is coming down the road. It's kind of like when you go to the movies and you see a trailer for a movie that hasn't been released yet. That's kind of what we're talking about here. There's a lot of talk, and I'm not going to go into it today. This is a subject for another rant, but there's a lot of talk about clear cooperation. That some of those issues are now before the United States Supreme Court. However, understand that while the matter is pending before the Supreme Court, and it might not be for another 6 months or a year before they make any kind of a ruling, it has been determined that there are no stays of any enforcement of any of the rules relating to clear cooperation coming soon and so forth. All right, so also want to remind you that the association has an outstanding program been recognized nationally. It's called the RED program, Rapid Ethics Delivery. If you think you have an issue with another broker or agent, give the staff a call and they'll guide you through the process to try and get these issues eliminated, and their success rate is in excess of 90%. So until the next rant, this is John Giardinelli signing off, hoping you have a profitable week. Keep an eye peeled for some upcoming classes on the new buyer broker representation agreement. We'll talk to you soon. Have a great day. Thank you very much.